Legal dictation 70 word per minute. The petitioner lodged a petition of complaint on the basis of which the police, after investigation, filed charge sheet under sections 468 oblique 471 oblique 120B of the Indian Penal Code against the opposite party numbers 2 to 10 on 17th November, 1995. Stop. The trial court examined witnesses number 1 and 2 and thereafter directed issue of summons to other witnesses. Stop. As the witnesses did not turn up, the magistrate closed the case and disposed of on the basis of the evidence recorded in the case. Stop. The de facto complainant came up to the High Court challenging the order of the magistrate by which the magistrate acquitted the accused persons on the ground that the magistrate was not justified in closing the case without issues summons and process attendance of the other witness. Stop. Para. The question for consideration was whether the magistrate was justified in closing the case and whether retrial shall be directed for securing attendance and examination of the witnesses. Stop. Para. Held. There cannot be any room of doubt that a long period of 23 years has been elapsed since initiation of the proceedings. Stop. The court could not procure attendance of any witnesses excepting two who failed to support the prosecution case. Stop. Those two witnesses were the main witnesses of the prosecution case, and one of them was the de facto complainant who on 7/2/2008 filed a verified application and prayed for disposal of the case on the ground that he was not willing to proceed with the case any further. Stop. Para. There is no dispute as to the legal principle that no precise time limit has been sanctioned by any law within which a trial is to be conducted. Stop. But, speedy trial being a constitutional right under Article 21 of the Constitution of India cannot be overlooked, especially when the main stakeholder of a criminal prosecution has no fault on his part in the matter of delay in prosecution. Stop. A period of 23 years is not a small one. Stop. It is found already that two of the accused persons have been died in course of trial. Stop. Obviously, most of the witnesses either have been retired or died. Stop. Their attendance cannot possibly be procured by the trial court if the matter is sent back to the learned trial court for retrial. Stop. The right to speedy trial and guiding principle that in invoking the Article 21 of the Constitution has been thoroughly discussed by the Honorable Apex Court in Abdul Rahim versus R.S. Nayak. Stop para. Taking everything into consideration, this court finds that it would be wastage of time and money of both the parties if the trial court is directed to start again the trial after issuing summons on the rest of the witnesses whose names have been mentioned in the charge sheet and pass a fresh judgment. Stop. This appears to be an impossible and useless job after such a long period of 23 years. Stop.